Welcome everyone to SQE1 window. We are going to learn client relations and legal services provision in chapter 2. Think of this as the how to be the client's best friend without ending up in court or with SRA. So at that point, grab your legal cup of tea and let's begin. The first thing we do is retainer agreement. So the retainer agreement is like, kind of like explanation to client what you will be doing for them. So think of it as a handshake, but with legal teeth. It sets out exactly what the solicitor will do and what the client can expect. A written retainer is ideal, like having the instruction manual for your new smartphone, but not strictly necessary. The key principle is act in the client's best interest and make sure they understand their protection. Don't leave them guessing, or they might start imagining you are casting spells instead of giving legal advice at that point. Make things very certain, and best practice is writing it. So, and the case law also advises, so it should be written. So, taking on client and obtaining instruction, you can generally choose your clients, which is lovely, but there are rules. No discrimination based on age, gender, race, or even whether they love pineapple on pizza. If they love it, you can't discriminate them. Conflicts of interest are a big no-no. If it is conflict of interest, of course, you can say no. If representing a client would put you in a pickle, like acting against a friend's former client, just say no, and you can. In that case, you are not going to discriminate. And remember, giving a second opinion is perfectly acceptable. You can be the friendly neighborhood solicitor without causing a turf war. Not at all. So, information regarding costs. That's very important. And many things get messed up, like if it is not properly done. So transparency is king here. Clients must know what your services cost and how the fee are structured. Think of it as giving them a menu like with prices. You are explaining the cost of your products or what you are going to sell them, rather than surprising them with a bill of the whole buffet. Update them if estimates change and discuss cost benefit analysis, because no one likes spending thousands of pounds to chase a claim that barely covers a taxi to court. So be mindful that you should give extra care to cost. Even solicitors are not they cannot run away from liability, So at that point, shocking, but your duty is to provide competent services without negligence. You can't exclude all liability. You can't run away from the liability, and client must have insurance protection. You may limit liability, but only if it is above the minimum insurance threshold and clearly communicated in writing to the client. Basically, don't try sneaky small print tricks. Not at all. It does not work. Clients, like cats, notice everything. Of course, they are paying you money and they will notice everything. So, duties that you owe to client during retainer. During retainer, the duties are simple but crucial. First, don't make secret profits. Your fiduciary duty is serious. Use proper skill and care. Keep everything confidential and always update the client. Consider their circumstances, especially if they are vulnerable. And remember, you must follow the SRA principles, even if the client insists on a course of action that would make your hair curl. You need to follow the guidance. So sometimes I've seen people stretching for their client. Not at all. You should not at the cost of your hard-earned license after passing your SQE. Termination of retainer is another thing. You can't just finish mid-case that I'm going to Spain for holidays. So terminate only for good reasons and with notice. Always hand over papers and explain options if the client moves on. Courtesy and clarity prevents awkward letters and angry emails. Trust me, it's easier than litigation. And also SRA is very, very vigilant. Liens, fancy word for I hold on to your stuff until you pay me. Proper bills must be delivered first. You can even ask the court for help or an equitable lien if you hold nothing valuable. Think of it like borrowing a friend's lawnmower. You can keep it until they finally pay you back. But don't be that friend who disappears with it indefinitely. Not at all. You can't in this profession. So, funding of legal services is very important. Fee agreement must be clear, legal, and tailored to client. Litigation is contentious, like personal injury, employment claims, criminal work, while non-contentious work cover like advice, pre-litigation matters, and certain tribunals. Always discuss funding, public funding, insurance, or private payment. Transparency is your best friend, like tea at 4 p.m. when you are quite tired. Be transparent, clear, and certain with your client to save yourself from SRA at the end. So contingency fee, like for example, CFA or DBA, CFAs are the classic no-win, no-fee agreement. Your fee may increase if the client wins, but capped at 100% of your usual profit, or 25% of damages in personal injury. DBA, that is, they are paid from damages with percentage cap depending on case type. Always in writing, always signed, always crystal clear. Think of it as negotiating a poker game. Everyone must know the stakes. So careful. So especially I would say go to our notes and look at CFAs and DBAs. So there are certain percentage that you can charge. So you must understand in personal injury, you cannot go beyond 25%, employment 35, another 50%. So be careful in all these, fee arrangements. CFAs, DBAs, there are certain limits you can do it, not beyond that. Okay, fee in non-contentious business. It can be fixed, contingent, or interim. Fixed fee must include everything: VAT, disbursements, and perhaps a dash of common sense, like you should keep in mind. Interim bills every 6 months are fine, and you cannot demand payment for work not yet completed. Simpler than a drama-filled courtroom, almost. So it's not always money, but you should be very careful about money. Non-payment of bills and rights to challenge. Clients don't always very welcome to adulting. You can sue unpaid bills after 1 month. You can challenge via detailed assessment with costs judged on standard or indemnity basis. Complaints unresolved by your firm can be referred to legal ombudsman. Essentially, it's a structured way to prevent your unpaid fee from ending up in a dusty drawer. And I found solicitors really smart with clients nowadays. They don't leave their money unknown. So, witness and counsel, finally, you need to remember you are personally responsible for paying barrister or agent you instruct. Usually within 30 days, even you are not paid. So you need to make this payment within 30 days. Think of it as paying the taxi driver promptly after a long court day. Keeps everyone happy and avoids a row. Our favorite SQE tips and pitfalls. Always remember the difference between contentious and non-contentious work. Examiner love trick questions here. No retainer duties and when termination is allowed. Understand liens, CFAs, DPAs, and how much you can do that with the client, how much you can charge the client, what is the limit. Cost recovery, standard versus indemnity basis. Like you need to understand the difference between these two. And finally, keep your humor and sanity intact. I wish you all the best with your preps. Ta-da!